Hearing in the appeal, Commissioners for Her Majesty's Revenue and Customs against Parry and others.
Now, Mr. Rees, it may help you if I tell you that we've, of course, read the parties' cases and the judgments below. I think we're pretty clear about what the issues are and what the stress points, if you like, are in each side's submissions. So we can really focus on the nitty-gritty.
I'm very grateful for that indication, my Lord. Perhaps I may just say a word or two by way of opening before descending to that nitty-gritty. I appear with my learned friend, Mr. Cumber,
Yes.
the taxpayers, and Miss Wilson appears for Her Majesty's Revenue and Customs. As your Lords, my lady, appreciate, this is an appeal in relation to the construction and interaction of certain key sections of the Inheritance Tax Act 1984 and requires focus on various words used by Parliament with particular precision. Those words such as disposition, transfer of value, transaction, operation, omission, to a layman may have fairly similar meanings, but it's clear that Parliament intended them to have very specific and technical meanings in the context of the statute. And each of those words has its own part to play in these proceedings, and there needs to be a focus on those words that Parliament used. Perhaps inevitably at each level, as the parties and the judges below have sought to explain these concepts, there has been a risk of perhaps placing their own gloss on some of the statutory words, and one sees that in my submission in some of the judgments where there is a move into language such as gifts, advantage, substituted rights. And in my submission, that approach can be apt to obscure rather than elucidate the underlying meaning of the words that Parliament used. I'd like to begin by focusing very briefly on what Mrs. Staveley did in this particular case. And this is a tax appeal, but it is an unusual set of facts because it's clearly never been a tax scheme as such. It is always something that Mrs. Staveley stumbled into. Before October 2006, she had a pension scheme. It was a Section 32 contract, but it was a commercial pension fund arrangement with a commercial pension fund provider. And the funds in that scheme were within that pension fund wrapper. That is to say, they weren't hers absolutely for her to do with as she wanted. Rather, there was a contract with the scheme provider, and under that contract, there were two sets of mutually exclusive rights. Mrs. Staveley could take a pension during her lifetime, or if she died before she took a pension, there was a lump sum death benefit which was payable under the scheme rules. And of course, by definition, that lump sum death benefit was never something Mrs. Staveley herself would ever receive, because it was only ever payable after her death. It was only ever payable somewhere else. Under the terms of that first pension scheme, the Section 32 contract, the death benefit was payable to her personal representatives, and the reference in the bundle to that, it's clause 1.8.4 of the scheme, which is at page 222 of the bundle. And what that meant was that Mrs. Staveley was able to decide by her will, or indeed by allowing the rules relating to intestacy to apply, where the death benefits would go. In October, or very end of October, beginning of November 2006, Mrs. Staveley made a transfer from that Section 32 contract to a personal pension scheme. That was, in some ways, a different type of pension contract, but essentially recognisable as very much the same sort of arrangement that had been in place prior to the transfer. One has the same two rights. They are, again, mutually exclusive, as before, the right to a pension during the lifetime, or a right to take a lump sum death benefit again payable in accordance with the scheme rules. This time, the scheme rules provided for the funds to be paid out within 2 years of Mrs. Staveley's death, and they were to be payable in accordance with Rule 14.1 of the scheme. And Rule 14.1 is at page 252 of the bundle, and essentially provided that if there had been an assignment into trust, it was to be payable to that. Subject to that, if there had been an assignment elsewhere, it was to be payable in accordance with that assignment. And then 14.1 Rule 4, if the previous provisions were not applicable, at the discretion of the scheme administrator, to or for the benefit of any one or more of the following in such proportions as the scheme administrator decides. That includes any person, charity, association, club, society or other body whose names the member has notified to the scheme administrator in writing prior to the date of death, a surviving spouse or civil partner, which wasn't applicable in Mrs. Staveley's case, parents, grandparents of the member or the member's surviving spouse, civil partner, and any children and remoter issue of any of them. Mrs. Staveley had 2 children living and a further grandchild born within the 2 years that this discretion was applicable. Dependents, any person, charity, association, club, society, or other body entitled under the member's will, or to the member's legal personal representatives. So the difference between the two schemes was that under the first scheme, the death benefits were payable to Mrs. Staveley's personal representatives, and essentially she had control of who would get those benefits if she wished to by making a will. Under the second arrangement, the benefits were payable at the discretion of the scheme administrators. And it's that transfer from one scheme to the other that is the disposition that gives rise, the revenues say, to the first transfer of value that took place here. That Mrs. Staveley disposed of the right to receive the death benefits. And it's that, the transfer, that is identified by HMRC as the disposition in question in their notice of determination in this case. Lords, my lady, I'm not suggesting you turn it up, but it's at page 208 for the bundle. And the taxpayer's case is we accept that it was a disposition, the transfer from one scheme to another, but we say it wasn't a transfer of value. And the reason that we say it wasn't a transfer of value is because it's prevented from being such by Section 10 of the Inheritance Tax Act. That's the first element of the appeal. Does Section 10 prevent the disposition that's identified in the notice of determination from being a transfer of value? And there are really 3 issues between myself and my learned friend on that first element. The first of those issues is what do the words intention to confer a gratuitous benefit mean in the context of Section 10 of the Inheritance Tax Act? Secondly, what are associated operations for the purposes of Section 10? And specifically, what did Lord Jauncey mean in the case of Macpherson when he said, if an associated operation is not intended to confer such a benefit, it's not relevant? And then the third issue is what one might term the Edwards and Bairstow issue, given that this is an appeal from a tribunal on a point of law only. Were the Court of Appeal entitled to interfere with the first-tier tribunal's findings of fact? Or perhaps a better way of expressing that question would be, were the first-tier tribunal entitled to come to the conclusion that they did? The second element of the appeal relates to what didn't happen. As long ago as 2003, before her original diagnosis of cancer, Mrs. Staveley had taken a positive decision not to access benefits from her pension fund, and that's in the first-tier tribunal decision at paragraph 140. The First Tier Tribunal held that she reconsidered the matter in June 2006 and again had decided not to take benefits. Again, that's paragraph 140 and 143. At the time she made that decision in June 2006, Mrs. Staveley knew she had cancer, but it was before she had accepted that her death was inevitable. That didn't take place until some months later in October 2006. And the FTT's finding was that there was no evidence that Mrs. Staveley ever thought about this issue, this matter of taking benefits or not taking benefits from her pension again. She died without having taken a pension, and the consequence of that, the revenue say, is that that was an omission on her part to take lifetime benefits. And had she taken those benefits, her estate would have been entitled to a 10-year guaranteed annuity. So the consequence of her failing to exercise that right was her estate was less than it would otherwise have been. But what was missing from her estate on the revenues case here is the lifetime benefits. This is why there are two issues, each relating to separate items of property. The transfer relates to the loss of the right to direct the death benefits. The omission relates to the loss of the lifetime benefits from Mrs. Staveley's estate. And the revenues say that that omission, coupled with the diminution in value in Mrs. Staveley's estate and the subsequent increase in her son's estate 6 months later, when the scheme administrator exercised their discretion to pay the benefits, to pay the funds from the policy out to the sons, amounts to a disposition and transfer of value by Mrs. Staveley by reason of section 3.3 of the Inheritance Tax Act. In our cases, the requirements for section 3.3 are not met, so this was not a disposition. And this element essentially poses two questions. Firstly, what is the nature of the causative connection that's required by section 3.3 between the omission and the increase in another's estate? And secondly, is it permissible to consider the facts, how likely it is that the discretion will be exercised in a particular way, which was the approach taken by the First Tier Tribunal on this point, and in my submission, also the approach taken by the majority of the Court of Appeal. To start then with the transfer, and I appreciate, my lords, my lady, that you will also already have looked at and I suspect in some detail sections 3 and 10 of the Act. But to start, the relevant provisions are, so far as the transfer is concerned, section 3 subsection 1 and then section 10. Section 3.1 provides, subject to the following provisions of this part of this Act, the transfer of value is a disposition made by a person, the transferor, as a result of which the value of his estate immediately after the disposition is less than it would be but for the disposition, and the amount by which it is less is the value transferred by the transferor. Section 10 is the key section in relation to the transfer, because it is that section that the taxpayers say prevents this particular disposition, the transfer from one scheme to another, from being a transfer of value. Section 10, it's page 306 in the bundle, provides that a disposition is not a transfer of value if it is shown that it was not intended and was not made in a transaction intended to confer any gratuitous benefit on any person, and either A, it was made in a transaction at arm's length between persons not connected with each other, or B, it was such as might be expected to be made in a transaction at arm's length between persons not connected with each other. And just to pause there for a moment, there is a typographical error, I apologise, in the Westlaw transcript. It should be, we've checked the Queen's printer's copy, it is indeed intended and not indented. The Relevant, to move on, the next relevant subsection is subsection 3, and this provides, in this section, disposition includes anything treated as a disposition by virtue of section 3.3 above, and transaction includes a series of transactions and any associated operations. I will look at the precise definition of associated operations in a moment when I come to that point, but I want to deal briefly with what I described as the first issue, which is what does section 10 mean when it speaks of an intention to confer a gratuitous benefit. Now, this is not part of my grounds of appeal, because this is a point where all three tribunals who have heard this case have found in my favour on this point. And my primary case in relation to this issue is that the Court of Appeal were right for the reasons that they gave, that an intention to confer a gratuitous benefit, and this is the judgment of Lord Justice Newey at paragraphs 83 through to 90, but in particular it's what he says at paragraph 88, where he says that the third interpretation, which is going back to paragraph 86, to ask whether the overall effect of the disposition was intended to be favourable to, I do apologise, it's page 140 in the bundle, to ask whether the overall effect of the disposition was intended to be favourable to or advantageous to the recipient of the benefit. And then at paragraph 88, Lord Justice Newey says, on balance, it seems to me that the third interpretation is the correct one, and describes then the dictionary meaning of confer and benefit. Now, this is really my learned friend's point, and it may be that this is a matter I'd be better dealt with in reply.
Yes.
But I would confine myself to a couple of observations on this issue. The only judge who has found in favour of my learned friend's construction on this point rather than mine is the minority judgment of Lady Arden in the Court of Appeal. In my submission, Lady Arden fell into error in her identification of what was the relevant disposition. As I've already indicated, my lords, my lady, the disposition which was identified by the revenue here was the transfer from one scheme to another. And that was a single act. Lady Arden, at paragraph 40, and this is page 131 of the bundle, held that the first tier tribunal had found that by executing the statement of wishes on the occasion of the transfer of funds, Mrs. Staveley had made a disposition with the intention of giving a gratuitous benefit to her sons. And in my submission, that was a misunderstanding by Lady Arden of the case. The disposition was the identified one, the transfer from one scheme to another, and it wasn't open to her to identify a separate disposition that hadn't formed part of the revenue's notice of determination or part of the appeal to the first tier tribunal. And having done that, that is, in my submission, one of the reasons she fell into error in concluding that the disposition had been effected with an intention to confer a gratuitous benefit. Secondly...
Sorry, just before you go on, are you able to help us as to which paragraph in the FTT decision Lady Justice Arden is referring to there?
Paragraph 50, I believe, my lord. They refer to the statement of wishes. This is paragraph 36 of Lady Arden's judgment. Paragraph 30, Lady Alden's judgment says only at paragraph 50 the FTT consider the statement of wishes, and this is rejected on the basis it's not a newly conferred benefit. In my judgment, it's implicit in this conclusion the FTT considered the statement each son was to receive 50% of the death benefit was indeed otherwise an intended benefit. And paragraph 50 of the FTT's decision is at page 183 of the bundle.
They're not identifying a disposition in that.
No, my lord. Well, my lord, the FTT's findings on what was the disposition, at paragraph 45,
Yeah.
which is identifying that the transfer from one scheme to another was the disposition for the purposes of section 3.1.
Yeah.
And that's what I'd submit. It was the first tier tribunal's findings on that point.
Thank you.
And the second brief point I would wish to make on this issue was that before the transfer, the sons were the person who stood to benefit from the death benefits. If those death benefits became payable, Mrs. Staveley didn't change her will, but their interest simply depended on what Mrs. Staveley did in terms of directing the benefits. Afterwards, the sons were persons who perhaps stood to benefit if the death benefits became payable and the administrator exercised their discretion. But again, they had no rights to receive those benefits. It simply, all that changed was the person who was going to be making the final decision about how the benefits were shared out. And these are, of course, death benefits which, by their very nature, as I've already mentioned, the benefits which could not have been, never have gone to Mrs. Staveley, but it's an inevitable part of any pension scheme that there is a set of rights that may be payable if the member dies before taking their pension. And then my third point is really just the natural meaning of the word confer and confer a benefit. I provide an example at paragraph 51 of my written case of a trustee reducing an interest in trust from 100% to 50% and saying that would be an unusual use of language to say that one is conferring a benefit by halving somebody's interest. It was never meant as an application of section 10, it was meant as an application of language, an illustration of how language is used. Rights change all the time. If I have a £20 note and change that to two £10 notes, the nature of the rights I have got has changed. The property I hold has changed. But one wouldn't say I was being conferred a benefit by changing a £20 note into two £10 notes. Parliament used this expression, intention to confer a benefit. And in my submission, the language that is used here clearly seeks to identify something additional, something beyond that which the person was already enjoying. And finally, I would just make the observation in relation to this, that both Lord Justice Newey at paragraph 94 and 103 little Roman 4, and 103 little Roman 4 is page 145 of the bundle, and Mr. Justice Burse at paragraph 115, page 148, both made the point, in their view, the first tier tribunal had been entitled to conclude that the transfer was not itself intended to confer gratuitous benefit. That conclusion was not Edwards and Bairstow wrong.
Can I just be sure that I'm understanding the argument? you say the transfer from the Section 32 policy into the PPP is a disposition as defined because Mrs. Staveley gave up the power to dispose of the funds by testamentary disposition, which she had previously possessed.
Yes.
And so the status quo ante was the Section 32 policy didn't in itself direct what was to happen to the funds. She had a power to dispose of them by will, and she had made a will nominating, under which the funds would go to her personal representative, and he, administering the will, would give it to the beneficiaries, who at the time were her sons.
Yes.
Although she could have altered her will at any time.
Yes.
Once the transfer had been made, the benefits in the event of her death would pass to the scheme administrator, who had a discretion as to what to do with them. She could make a letter of wishes recommending what she would like to be done with them, and she did that, indicating a desire that the funds should be paid out to her sons. But again, that was something which she could revoke whenever she pleased.
She could certainly have revoked it. She could even, of course, have exercised her right to transfer into yet another pension scheme with different arrangements. But it's simply that the only difference in practical terms between the two schemes was who did the selecting of how these death benefits were to be paid out.
At some point, I appreciate it's perhaps more of an issue and more relevant to the second issue in the appeal, but at some point it would be useful, I think, for us to know a little bit more about the treatment of arrangements involving the exercise of discretion and letters of wishes in inheritance tax. Because effectively, the revenue's argument on the second point is that it's a formality.
Yes.
But a lot of people execute discretionary trusts under which their estates pass to trustees, and they will give them letters of wishes, and that's not treated as a formality for tax purposes.
Certainly not. There are perhaps two issues there, and I've actually just addressed them very briefly, my lord. So far as trusts are concerned, there is an entirely separate element of the Inheritance Tax Act that deals with the taxation of trusts. And we haven't set out those provisions in our written cases because they're not directly relevant to what happens in this particular case. But there is an entire regime that deals with the taxation of what's called relevant property. And essentially, property that is in a discretionary trust is treated as relevant property for the purposes of the Inheritance Tax Act. Once one is in that regime, the way property is taxed is very different. If it enters that regime or leaves that regime, charges may arise, and there is a decennial charge once every 10 years on the value of property within that. Now, under the Inheritance Tax Act, anybody who has got simply an object of a discretion under a discretionary trust, they're not treated as owning any property as such. It's not an interest within their estate for inheritance tax purposes. But it's held subject to these discretions by the trustees and falls into this separate arrangement. But certainly discretions that are exercised by trustees are looked upon as real things for the purposes
Yes.
of the Inheritance Tax
Yeah.
Act.
Yeah. Yes, thank you.
That's all I propose to say at the moment in relation to this first point, what was an intention to confer gratuitous benefit. It's really my learned friend's point, and I'll return to that in my reply if necessary. I would like, therefore, to turn to the second issue, that of associated operations. And this is the point on which the Court of Appeal decided that the transfer from the Section 32 contract to the personal pension fell to be treated as a transfer of value. Now, associated operations are provided for in Section 268 of the Inheritance Tax Act, and your Lordships, my lady, finds that at page 313.
Just before we get to that, can I just ask, in Section 10, subsection 3,
Yes.
the definition of transaction as including a series of transactions and any associated operations, are those two phrases, a series of transactions, any associated operations, are they to be read disjunctively? In other words, we're not talking about a single thing, which is a series of transactions and any associated operations.
The way Lord Jauncey read it in the Macpherson case was that this is, I'll come on to Macpherson in a bit more detail in a moment, but it's page 331 in the bundle, page 175 of the report at letter G. Lord Jauncey says, if the extended meaning of transaction is read in the opening words of section 20 subsection 4, the wording becomes a disposition is and transfer of value. If it's not shown it was intended and not made in transaction, including a series of transactions and any associated operations intended to confer any gratuitous benefit. So read, it's clear the intention to confer gratuitous benefit qualifies both transactions and associated
yes,
operations.
thank you.
So it certainly seems as if the House of Lords on that occasion, my lord, were treating that one can either have a series of transactions and or associated operations.
Yeah. Thank you.
To turn then to section 268, and as I've already mentioned, this is in this is a section which on its face is in very wide terms. Section 2681 provides in this act associated operations means, subject to subsection 2 below, any two or more operations of any kind, being A, operations which affect the same property, or one of which affects some property, and the other or others of which affect property which represents, whether directly or indirectly, that property, or income arising from that property, or any property representing accumulations of any such income, or B, any two operations of which one is affected with reference to the other, or with a view to enabling the other to be affected, or facilitating its being affected, and any further operation having a like relation to any of those two, and so on, whether those operations are affected by the same person or different persons, and whether or not they're simultaneous, and operation includes an omission. So it's very clear there that on its face, Parliament was using extraordinarily wide language. And as counsel for the taxpayers in Macpherson, Robert Walker, Queen's Counsel, as he then was, pointed out, and this is at page 162, letter B, 318 in the bundle, that the definition of associated operations is so wide that the whole history of a trust is almost by definition a series of associated operations. And so it has always been understood, both by the revenue and by the courts, that notwithstanding the extraordinarily wide language that Parliament uses in section 268, it is necessary to place a limit on the application of the section in order to give a meaningful purpose to it. Now, associated operations are relevant in the context of Section 10 because of their relevance to the expanded meaning of the word transaction, both in the first limb of Section 10, the subjective test, the intention to confer a benefit, and in the second limb, in the objective test, when one is looking to see whether the transaction is an arm's length one or such as might have been made in an arm's length one. It's also worth, by way of introduction, just making the point that Section 268 is not itself a charging provision. It is simply a provision to help expand the meaning of certain words. In the context of Section 10, it's the word transaction that's being focused on. But Section 272 of the Act, which is the definition section, provides that the definition of disposition also includes dispositions effected by way of associated operations. So it's relevant in that context as well. I now turn, my lords, my lady, to Macpherson itself. This is the leading case on what is now Section 10. And I do just make the point that it's never been suggested by either party at any stage in these proceedings that this decision of the House of Lords was wrongly decided. It related to a discretionary settlement that had been created at some point in the 1950s. In 1970, the trustees of that settlement signed an agreement under which a beneficiary, D, undertook custody, care and insurance of certain valuable pictures that were within the terms of the trust. And he paid £100 per annum in relation to that. And that agreement was terminable on 3 months' notice. In 1975, the trust was varied by an order of the High Court, and D was excluded from benefit. On the 29th of March 1977, the trustees varied their agreement with D, limiting his liability in relation to the pictures, reducing the annual payment to £40 a year, removing the right to terminate the agreement, with the agreement being said to last until the 1st of April 1991. And that agreement had the effect of devaluing the pictures in the trustees' hands. The very next day, the trustees appointed an interest in possession in the pictures to a beneficiary under the trust. Now, that appointment was itself taxable, but in a lower amount than would otherwise have been the case had the depreciatory transaction not been entered into. And the question arose as to whether or not that depreciatory transaction was itself taxable. Mr. Justice Goulding held for the taxpayers and held that it wasn't, but he was overturned by the Court of Appeal, and the Court of Appeal were ultimately upheld by the House of Lords. And the issue in the case was whether or not charge to tax was excluded by Section 20, subsection 4 of the Finance Act 1975, which is essentially the predecessor of what is now Section 10, and it's in the same terms. There was a paragraph of the evidence which is set out by Lord Jauncey at the bottom of page 170 at letter H, page 326 of your Lordship's bundles, which played a role in the court's reasoning. And that's the quotation, that the trustees have come to the conclusion they ought not to exercise their power of appointment, so as to give Mr. Robarts' eldest son Timothy an interest in possession in the pictures, unless the terms of the 1970 custody agreement were first reviewed and varied, since Mr. Robarts was not willing to continue after such an appointment to house the pictures on the terms of the 1970 custody agreement in its original form. And that finding that element of the evidence was recognised by Lord Jauncey as being an essential part of the evidence, and there's a reference to that at page 175 at letter C, at page 331 of your Lordship's bundle.
So is that the explanation of the agreement? First of all, on the 29th of March 1977, varying the 1970 agreement, and then the agreement, what a deed of appointment the following day.
Yes, yeah. And the evidence is that they weren't going to make the appointment unless they...
Yeah.
They ought not to exercise the power of appointment unless the terms of the custody arrangement were first reviewed.
Yes.
So the second element, it was quite clear on the evidence, was entirely contingent upon the first taking place, and that's referred to by Lord Jauncey at 175. And again at 176 at letter B, in this case it's common ground that the appointment conferred a gratuitous benefit on Timothy. It's clear from paragraph 17 of the trust solicitor's affidavit the appointment would not have been made if the 1970 agreement had not been varied by that of 1977.
Yes, and so one gets a reference to between B and C.
Contributory part.
A contributory part of a scheme.
Indeed, and one has to just go back a couple of paragraphs to what is really the key passage of Lord Jauncey's decision. And it begins at 175, just over a third of the way down the page, where he refers to, in determining whether the 1977 agreement was made in a transaction with the extended meaning intended to confer a gratuitous benefit, it's necessary to consider what are associated operations for the purposes of the subsection. The definition in section 44 is extremely wide and capable of covering a multitude of events affecting the same property, which might have little or no apparent connection between them. It might be attempted to assume that any event which fell within this wide definition should be taken into account in determining what constituted a transaction for the purposes of section 20, subsection 4. However, counsel for the Crown accepted, rightly in my view, that some limitation must be imposed. The reference to that concession, which was Mr. John Mummery, as he then was, who was appearing for the Crown, is at 168H of the report, 324 of your Lordship's bundle. Then after a reference to the case of IRC and Herdman, Lord Jauncey continues just below letter F. Lord McDermott, Chief Justice, at page 406, upheld a submission by the taxpayer that the only associated operations which were relevant to the subsection were those by means of which, in conjunction with the transfer, a taxpayer could enjoy the income and did not include associated operations taking place after the transfer had conferred upon the taxpayer the power to enjoy income. If the extended meaning of transaction is read into the opening words of section 20, subsection 4, the wording becomes, a disposition isn't to transfer of value if it's shown that it was not intended and was not made in a transaction, including a series of transactions and any associated operations intended, to confer any gratuitous benefit. So read, it's clear that the intention to confer gratuitous benefit qualifies both transactions and associated operations. If an associated operation is not intended to confer such a benefit, it's not relevant for the purpose of the subsection. That is not to say that it must necessarily per se confer a benefit, but it must form a part of and contribute to a scheme which does confer such a benefit. And then, in the passage I've already read, Lord Jauncey goes on to hold that the agreement was intended to form part of and contribute to a scheme in conferring a benefit. Lord Jauncey then went on with a view to identifying the importance of the operations being relevant associated operations, to consider the counterfactual case. And this is the paragraph beginning at letter C. Counsel for the trustees argued that if the agreement was a relevant associated operation for the purposes of section 20, subsection 4, an anomalous result would follow, inasmuch as double taxation would occur if the order of events which actually took place had been reversed. Thus, if the appointment had been made first, a charge on the whole value of the sum appointed would have arisen under paragraph 6.2, and when the agreement was subsequently entered into, a further charge on the amount of the devaluation would arise under paragraph 6.3. I do not consider that such a result would have ensued. The agreement would undoubtedly have been associated with the appointment within the definition of section 44, but it would not have been a relevant associated operation, since it would have contributed nothing to the conferment of the gratuitous benefit which had already been effected by the appointment. It could alternatively be said the transaction intended to confer the gratuitous benefit had already been completed before the agreement had been entered into. Therefore, though it was an associated operation, it could not be said to have been made in that transaction. The concept of associated operations has been looked at subsequent to Macpherson in a few authorities, and there are some of those within the authorities bundle, which I'll just take the Lordships to very briefly. These are not so much in the context of section 10, but in the context of section 272 and a disposition having been effected by way of associated operations. But they do make reference to Macpherson, so I would invite your Lordships to look briefly at those. The first of those is the decision...
Just before you leave this, as we've got it open at the
Yes.
top of the page, in that critical passage, the one that goes over the page,
Yes.
are there two concepts involved in it? That is to say, not intended to confer a benefit and actually conferring a benefit.
There
In
are...
other words, the first complete sentence on the
Yes,
second.
and that's not my case, my lady, that there are two separate concepts, conferring a benefit and being intended to confer a benefit. And what Lord Jauncey is saying here is that each transaction / associated operation must be qualified by that intention. It doesn't matter that that particular transaction or transaction in the narrow sense or operation doesn't itself confer the benefit, but it must be qualified by that intention.
It's got to be part of a single scheme with that intention.
With that intention. But it doesn't matter that each individual step itself provides a benefit.
He moves, in a sense, away, though, from the concept of whether the individual act is intended to confer a benefit and starts looking at it in terms of scheme. So you're looking at the intention of the scheme and whether it forms part of it.
Well, I would say not, my lady. He says the intention to confer gratuitous benefit qualifies both transactions and associated operations, and their transactions being meant in the narrow sense. If an associated operation is not intended to confer such a benefit, it's not relevant for the purposes of the subsection. So what, in my submission, Lord Jauncey is saying there is that the hallmark of whether any individual narrow transaction or associated operation forms part of the scheme is whether it's qualified by that intention. Because otherwise one ends up with the position, in my submission, this is where the Court of Appeal fell into error, that if one, when looking at an individual narrow transaction or operation, if it neither has to confer a benefit, and Lord Jauncey says it doesn't, nor has to be qualified by an intention to confer a benefit, and the Court of Appeal said it didn't, then one is left at sea in trying to determine what actually is the scheme. If you can't identify the hallmarks of the individual elements within the scheme by saying whether it has that intention, then one is in a position where one is essentially back at section 268 with the vastly wide definition that the Court of Appeal, that the Parliament put in place. And in my submission, what the Court of Appeal did here was to come up with a definition that essentially begs the question of what is in the scheme. Because somehow one has to identify each element of the scheme. And if one isn't doing it either by the way of the fact that it actually confers a benefit, or that it was intended to confer a benefit, then how do you identify what is and isn't part of the scheme? And one is back to Mr. Robert Walker's, Queen's Counsel's, posed question in his submissions in Macpherson, that the breadth of the section means that any act in relation to a trust virtually is technically an associated operation.
Yeah, and really it's what he says in the passage that my lady referred to is really implicit in what he says at the foot of 175. If the intention to confer a gratuitous benefit qualifies the phrase associated operations, then it must be possible to say that those operations viewed as a whole are subject to that intention.
Yes.
And therefore any individual operation either has to itself have that intention, or it has to form part of an arrangement or scheme that has that intention.
But how does one identify what the scheme is? And in my submission, that the only way to do that is to do what Lord Jauncey says, which is ask, does this have the hallmark that it was intended to confer, this particular element of the scheme was intended to confer a benefit? And if that hallmark is missing, it's not part of the scheme.
But it may be that you have a scheme which is intended to confer benefit, but this is an element getting there.
Precisely.
Yeah.
A necessary element or a chosen element, or whatever way you want to describe it.
Yes.
Now, I don't really understand the idea that you cannot identify a scheme where one element of the scheme of itself doesn't confer a benefit. Yeah. The task surely is to look at the series of transactions in the round and say, as a whole, is this something that is intended to confer a benefit? And if the answer to that is no, then you look at the individual transaction on its own.
My Lord, within each element, in my submission, it is necessary for each element of the scheme to be qualified by that intention. Lord Walker, sorry, Mr. Robert Walker, as he then was, gave an example in the course of his submissions in Macpherson of a composite transaction which might be caught by a scheme. That's at 162 letter F, when he referred to a three-corner transaction where A lets Blackacre to B on the condition that B surrenders his tenancy of Whiteacre Farm belonging to A's son C. And that, he says, in such a case, the associate operations do, on a common sense view, form one transaction, and the words at the end of section 20, subsection 4, serve to avoid any doubt about that type of case. That's the sort of transaction where, although on its face, perhaps, each individual element, or for example, the letting of Blackacre to B, is not of itself obviously intended to confer a gratuitous benefit because it may be at market value, it is nonetheless hallmarked by the overall intention of what was going on within the scheme, because it was clearly always conditional that point one would happen, the letting, but it was conditional on the surrender taking place as well. So there, the hallmark would be present. But in my submission, that hallmark must always be present, because if one has, otherwise one is simply begging the question, what is a scheme? And section 268, on its face, is wide enough, as I say, that a whole trust and everything that happens under a trust could be a scheme. That's clearly not what Parliament intended, and it's not what the House of Lords said Parliament intended in
section 10.
Yes.
Yes.
The way that you took us to a passage on 176 of a report between D and E, which is perhaps helpful, where considering the counterfactual argument, it says that the agreement would undoubtedly have been associated with the appointment, but it wouldn't have been a relevant associated operation since it would have contributed nothing to the conferment of the benefit.
Yes.
So, I mean, clearly in Ramsey-type arrangements, you might well have an operation which formed an essential part of the process, if you like, by which the benefit is eventually conferred.
Yes.
That doesn't in itself confer the benefit, but it contributes to the conferment of the benefit.
It contributes and is qualified because by the intention to confer a benefit. And that's what Lord Jauncey in my submission is saying. He's making this very clear distinction between conferring a benefit itself and intending to confer a benefit. And that's what the focus has to be on. And what is necessary is for there to be an intention to confer a benefit attached to each element of the scheme. Is this convenient to move on to look briefly at those other cases?
Yes, certainly.
I was going to take your lordships, my lady, first to the case of Rayno and IRC, which is in the authorities bundle at tab 17, page 508. And these are all cases where the tribunals or courts these are all cases where the tribunals or courts were looking at the extended meaning of disposition rather than section 10 points, but they do pick up on Macpherson and what was said by Lord Jauncey on associated operations.
I just won't note it.
Rayno, which is a report of the special commissioners, this was a case where the settlor had transferred shares in a company into a discretionary trust, and then the company had in fact bought back its shares from the trust. And the revenue were arguing that this was a disposition of cash rather than the shares by way of associated operations, and that was relevant because it was related to the availability or otherwise of business property relief for inheritance tax purposes. The special commissioners held that this wasn't a disposition by associated operations. The relevant passage of the judgment starts at page 190, page 513 of your lordship's bundle. Having looked at the definition of disposition as extended by section 272, reference was made to Macpherson and what Lord Jauncey said there. So that at the top of page 191, having set out the key quotation from Lord Jauncey and Macpherson, it said, it was clear that if the first transaction had not taken place, the second would not have followed. And so that they were associated, because they both formed part of a scheme which conferred such a benefit. They were both relevant associated operations. Taxpayers couldn't bring themselves within what is now section 10. In that case, the associated operations were relevant because they formed part of the transactions intended to confer gratuitous benefit on the life tenant, which was the wording of section 10. We consider the same principle follows in relation to the definition of disposition. In order to be a relevant associated operation, it must form part of the scheme reducing the value of the person's estate. So the special commissioners picked up and applied what Lord Jauncey had said in Macpherson in relation to dispositions. He then referred to Lord Jauncey's counterfactual, and the special commissioners concluded, just below letter E, although obiter, the same reasoning is applicable to the facts of this case. Here the value of the estates of the brothers were diminished as a result of the gift into the settlement alone. The purchase of the own shares contributed nothing to the diminution which had already occurred. It wasn't therefore a relevant associated operations. And so that they found that the purchase of the shares was not an operation which was part of the disposition reducing the value of the shares. The other authority I wish to take your lordships, lady, to very briefly is that of RISAF Trustee Company and IRC. The first instance decision, or rather the first appeal, was the decision of Mr. Justice Park. It's behind tab 18 of the authorities bundle at page 516. These were 5 settlements that had been created by separate trust deeds a few days apart, with shares transferred to each settlement by a settlor. And HMRC sought to argue that this was a single disposition by associated operations, so that essentially it should be treated as a single settlement. The Special Commissioner held that they were, that associated operations did apply, and this was a single disposition. And there was an appeal by the taxpayers to Mr. Justice Park, who held that it was not a single disposition and that associated operations were not relevant. The key part of the judgment is at paragraph 26 on your lordship's page 538 and following. Paragraph 26, Mr. Justice Park says, I wish to begin by making some general observations about the associated operations provisions before turning to how they've been held by Dr. Bryce, that's a Special Commissioner, to apply in this case. The definition of associated operations is quite wide, although in my opinion it's not quite as wide as Dr. Bryce considered, but the practical operation of associated operations provisions is comparatively limited. It is not some sort of catch-all anti-avoidance provision which can be invoked to nullify the effectiveness of any scheme or structure which can be said to have involved more than one operation and which was intended to avoid or reduce inheritance tax. The point is vividly illustrated by Countess Fitzwilliam and IRC. And he then talks about the levels of tribunal through which that case went. Just below letter E, the judge continues, originally one of the revenues arguments designed to defeat the effectiveness of the scheme had relied on associated operation provisions in the statutory predecessor of section 268. However, as Mr. Justice Vinelot recorded at the first instance hearing before the Special Commissioners, the revenue abandoned that particular argument and sought to rely on different grounds. Mr. Justice Vinelot commented that the associated operations provisions in legislation have a very limited scope. And the judge went on to hold, in this particular case at paragraph 34, that it was wrong to say that the shares were held on discretionary trust by virtue of a disposition effected by a single operation, because it was neither necessary nor appropriate to invoke or apply the extended statutory definition in order to conclude that each parcel of shares had gone into a trust at the time when it was placed there. That case was then taken to the Court of Appeal, and the Court of Appeal's judgment is the next tab, tab 19, page 544. And I should have just mentioned, I apologise, my lords, that Macpherson was referred to by Mr. Justice Park, as was Raynaud, and they form part of his decision that associated operations did not apply in this particular case. It was Mr. Justice Park was upheld by the Court of Appeal. That's tab 20, page 544. And at paragraph 23 of the judgment, it's judgment of Lord Justice Mummery, of course being counsel for the Crown in Macpherson, he identified just above letter E that the identity of the disponer and disponee under the dispositions and the subject matter of the dispositions were plain. The inclusion of associated operations in the statutory description of disposition is not intended for cases such as this, where there's no dispute that there was a disposition of property falling within section 43.2. They're intended for cases where there is a dispute as to whether there was a relevant disposition at all. The revenue may be entitled to invoke the extended description to catch a case which would not be regarded as a disposition of property in its ordinary and natural sense. I bring those authorities to your lordship's attention because they do emphasise, they are judicial emphasis at various levels of the limited scope of the association operations provisions. I would say not just in terms of identifying disposition, but given that all of these authorities have relied upon Macpherson as the basis on which they've reached their decisions, that it is clear that, in my submission, Macpherson again recognises, and the House of Lords and Macpherson recognised the limits that needed to be placed on associated operations, and they're not to be used to look for a wide scheme. One must look at the individual elements and fairly determine, having regard to the intention for each element, whether or not one has a transaction in the wide sense or not. I've mentioned already the Court of Appeal's decision on this issue. It was dealt with by Lord Justice Newey, and this was one of the points where the Court of Appeal were unanimous in their conclusions. It's Lord Justice Newey at paragraph 103, little Roman 4. At page 145 of your Lordship's bundle. And there he said, the fact that transfer to the PPP was not intended of itself to confer a gratuitous benefit, because Mrs. Staveley was not intending to improve her son's position by it, cannot without more prevent it from having been a relevant associated operation. There is, I think, no question of each individual operation and or transaction in associated operations having to have been intended itself to confer a gratuitous benefit. As Lord Jauncey indicated in Macpherson, an operation need not necessarily per se confer a benefit, but may form part of and contribute to a scheme which does confer such a benefit. Good enough, therefore, a scheme of which an operation forms part is intended to confer a gratuitous benefit. And in my submission, this is a misunderstanding of what Lord Jauncey said. In my submission, what Lord Jauncey had found was that it didn't matter if an element in the scheme didn't confer a benefit, but that each element, as I said, had to be qualified by that common intention to confer a benefit. Indeed, I would also say to confer the same benefit. But that if Lord Justice Newey is right here, then an element in a scheme need neither confer nor be intended to confer a benefit. It just needs to be part of a bigger scheme. And in my submission, that just begs the question of how one identifies that scheme, or to stick more closely to the statutory wording, the transaction in the wider sense, if that common intention for each element isn't required. In my submission, Lord Jauncey's words are clear, and the upper tribunal correctly identified it. Certainly there's no suggestion on either side that what Lord Jauncey says is wrong. And in my submission, it was merely misapplied by the Court of Appeal in Lord Justice Newey's reformulation. The transfer and the omission here were operating on different rights. The transfer was the redirection of the destination of the death benefits. The omission led to Mrs. Staveley not receiving lifetime benefits. And in my submission, the first tier tribunal, and I'll come on to the facts in just a moment, were entirely entitled to find that the transfer to the PPP wasn't intended of itself to confer a gratuitous benefit, and that the transfer and the omission were not unmotivated. Having reached those conclusions, there's simply in my submission no basis, having regard to what Lord Jauncey says in Macpherson, to invoke associated operations. The two events were not done with the intention of affecting the other.
Can I just ask you a factual matter?
Yes.
If the monies had not been transferred from the Section 32 contract to the PPP, would it still have been possible, by omitting to draw down in life, for a sum to have been built up that was greater to go into the testamentary disposition?
What would have happened was that the value of the fund at the date of death would have been paid to Mrs. Staveley's personal representatives and applied under the terms of her will.
And it would have been a greater fund by virtue of her not having drawn any lifetime benefit.
She didn't draw a benefit from either scheme.
But the reason I'm asking the question is, suppose that by her omitting to take any benefits during her life, she wouldn't have got any more money into her estate to go to her beneficiaries on the first scheme, but she would on the second, then...
No, the value of the fund was the value of the fund.
Fine.
If she'd placed more money into her pension, then the value of the fund would have gone up. But either way, it was simply whatever is in the fund will go to, if I don't take any benefits, will go to my beneficiaries. There may have been a difference in the way that the revenue would have sought to have taxed them on death, but it's clear from the tribunal's findings of fact that Mrs. Staveley was unaware of that.
Yep.
Does it depend partly upon how broadly one characterises the nature of the intention? The majority of the Court of Appeal and Lord Justice Newey in subparagraph 5, in the last sentence of that paragraph, he appears to be characterising the relevant intention as being one to ensure that death benefits could be passed to her sons. And if you characterise the intention that broadly, then is he not right in saying that the transfer into the PPP was carried out in pursuance of that intention?
No, my lord, and I will go on to I was about to go on to the Edwards and Bairstow point, which is really this what I would say is the recategorisation of the facts by the Court of Appeal. It comes back to the way I described the pension funds at the beginning. One has a sum of money. It's there in a wrapper. There are two possible and mutually exclusive sets of rights. One is that Mrs. Staveley takes the pension benefit during her lifetime. The other is she doesn't, in which case the pension benefits are paid under the scheme rules, whatever the scheme rules may be. Mm-hmm. The transfer, and this is the key finding of fact the first tier tribunal made, was that was solely because Mrs. Staveley was concerned by what by this stage was in fact a fanciful, but nonetheless in her mind real risk, that there was the possibility that her former husband and his company, Morriford, could somehow receive something from that. And the I started by saying these were very unusual facts. This isn't a tax scheme. The outcome of this case depends on the first tier tribunal's conclusion that that was her sole reason for making the transfer. But in my submission, they were perfectly entitled to do that. And I'll come on to the reasons for that in a bit more detail in just a moment. But having made that decision and that finding, the FTT are entirely entitled and right, in my view, to conclude there wasn't a link of motive between the omission and the transfer. So having promised...
Yes, there was no scheme.
There was no scheme.
There was no scheme with an intention to confer a gratuitous benefit.
No.
So a lot depends on the Edwards and Bairstow point. Mm.
Which I will come on to now, my lord.
Yeah. I mean, just thinking it through, Lord Justice Newey has earlier rejected the contention that the disposition affected by the transfer of the funds into the PPP was itself intended to confer a benefit.
Yes.
So that's out of the picture. So in order to be a relevant associated operation, it would have to be something which contributed to the conferment of the benefit, which eventually happened via the decision not to take any lifetime benefits.
Can I pick your lordship up on what it had been
the decision not to take lifetime benefits was prior. Yes.
Indeed, the factual findings are that was a decision taken in June.
Yeah.
And she never thought about it again.
Yes.
There are, I accept, references in the First Hill Tribunal's judgment to attributing what her intention must have been at the last point, but those were answering legal questions that I had raised in relation to the taxation of the omission and whether I could rely on Section 3.3, Section 10 in relation to the taxation of the omission. Those were the application, essentially, of the deeming provisions of 3.3. What was her intention at the latest time she could have exercised her rights? That's because I ran that defence in relation to the taxation of the omission, the tribunal had to consider that point.
Yes.
But that doesn't affect the actual facts in relation to the transfer, which is their finding that she thought about it in June at a time when she had not yet intellectually accepted that she was going to die, and she never thought about it again.
I suppose whatever the force of the timing point, if you keep your eye on what the disposition is, and the disposition is her divesting herself of the power to dispose of the death benefits by will,
Yes.
that was not a step, you would say. That did not form a step in the conferment of a benefit on her sons.
I don't have to go that far, my lord. All I have to say is that the First Tier Tribunal were entitled to reach that conclusion. And that brings me neatly perhaps on to Edwards and Bairstow. The Court of Appeal, and this is Lord Justice Newey at 103 subparagraph 5, page 145, says that the FTT was, in my view, mistaken in considering there was no intent linking. The Court of Appeal were taken to Edwards and Bairstow, and of course I entirely accept, and I'm sure Lord Justice Newey had in mind when he used the word mistaken, the Edwards and Bairstow test. And your lordships are thoroughly familiar that the test as formulated by Lord Radcliffe in Edwards and Bairstow is no evidence to support the determination. Evidence is inconsistent with and contradictory to the determination, and the true and only reasonable conclusion contradicts the determination. I'm sure I don't need to take your lordships to the decision in Edwards and Bairstow, but it is there in the authorities bundle, and Lord Radcliffe's dicta is page 468 in the bundle, by way of reference. And the key findings of fact of the First Tier Tribunal, I would take your lordships to paragraphs 61, 64 and 69. 61 is at page 185 in your lordship's bundle. The use of the word associated presupposes there's some connection between the operations. Section 268 should be read as requiring some sort of association between the two events. We find as a matter of fact they were not associated. Mrs. Staveley's decision not to exercise her pension benefit was a continuing decision which she made in respect of both the Section 32 policy and the PPP. Nothing changed in this respect when the transfer from the Section 32 policy to the PPP took place. The two decisions were entirely independent of each other. Indeed, it was clear from the letter of October the 31st she'd already decided to continue omitting to take the lifetime benefit from her pension fund while asking for advice which led to the transfer of the fund to the PPP. The events were not connected.
Yeah.
Similarly, at 64, we find as a fact that the combination of the two operations wasn't intended to confer a gratuitous benefit. Whatever the intent behind the omission, it was not linked with the transfer to the PPP in Mrs. Staveley's mind. Her intent with respect to the transfer to the PPP was, we have found paragraph 48, solely to break the connection with Morayford. There was no intent linking the two matters. And then at 69 over the page, we have found that the transfer to the PPP was not intended to confer a gratuitous benefit. We've also found it was not part of, nor did it contribute to a scheme which did confer such a benefit. This is because the transfer and the omission were not linked by motive. This is in contrast to the position in Macpherson, where it seems the Lords were of the view that the devaluation of pictures by the variation to the contract was done with the intent of making a gift of them the next day. In this case, the transfer to the PPP was not made with the intent of omitting to take the lifetime benefits. Insofar as Mrs. Staveley made any positive decision not to take lifetime benefits, that decision had already been taken and taken independently of the decision to transfer the funds to the PPP.
Yeah.
So those are the conclusions of the first tier tribunal. And the evidence on which they reached those conclusions is in my submission justifies their conclusion. It was quite clear from the evidence before the tribunal that the question of the possibility of any funds reverting to her husband or to Morayford had been exercising Mrs. Staveley for many years. That's recorded by the FTP at paragraphs 11 and 12 at page 176 of their judgment. And the underlying documents which led to those decisions are, I won't take your lordships to them, but I'll give the references, can be found in the appendix, in the second part of the appendix, behind tabs 20, 21, 22, and 27. And those include the references to the notion that if any part of the Morayford pension scheme were to accrue back, this would be totally unacceptable to Mrs. Staveley. And so it can be seen that over the years she was horrified by this, and indeed the reference at tab 27 to part 2 of the appendix is a letter when she was discussing the investment strategy for the fund, and was saying, what's the point of investing for growth if this is just going to go back to my ex-husband? There's the very vivid recollection of my client, Mr. Piney, at paragraph 15 of the FTT's judgment, where he referred to his mother having expressed the desire to ensure that that bastard doesn't get his hands on the money. And there's the concerns that were recorded in the June letter of Mr. Spratt of C. Hoare and Co. And that is at page 279 of your lordship's my lady's bundle, referring to the section 32 death benefits. And Mr. Spratt advised Mrs. Staveley, your concern is that surplus funds after paying out retirement or death benefits could be returned to your former employer, your ex-husband's company. However, from the 6th of April 2006, the death benefits rules became more generous with lump sum death benefits of a fund value up to 1.5 million being payable to beneficiaries. Our interpretation of the new rules is that as your lump sum would be within this limit,
I do beg your pardon, I'm struggling to find the page.
Which page?
279, I apologise, 279 in the main bundle. It's the end of the appendix, first part of the appendix.
Ah, yes. In the core bundle.
Yep.
The core bundle, yes.
Yes.
And it's the bottom of page 279, those two paragraphs there.
Thank you.
It refers to the rule changes that took place in April 2006 to pension benefits. And then continues, our interpretation of the new rules is that as your lump sum would be within this limit, all benefits should be paid to your named beneficiaries. Then, key sentence, this is new legislation and may be challenged by your former husband. In order to remove all the concerns you have about this matter, you could transfer your Section 32 policy to a PPP, and this would completely sever any link with the company. You could do this without needing to take any tax-free cash or income. And then, in October 2006, Mr. Spratt wrote to Mrs. Staveley, and that letter is over the page at 281 in the same bundle. In the first paragraph, I wrote to you on the 20th of June with advice on ways in which you can access your pension policy. My advice at the time was to defer taking your pension benefits for the foreseeable future. I also advised if you had any concerns about the possibility of any pension death benefits being transferred to your ex-husband, you could transfer to a PPP without taking pension benefits. I understand that having agreed with my advice to defer drawing your pension benefits, you are now keen to ensure that at no time should your ex-husband benefit from your pension fund. This letter therefore describes how this can be achieved. This letter solely addresses this issue, as this is the only area that you require advice on at the current time. So in terms of what Mrs. Staveley was thinking about and why, thinking about at the time she made the transfer, and why the exclusion of her ex-husband and his company was so important, those are the references to the evidence. As to the omission, I've already referred, and this is at paragraph 143 of the first-tier tribunal's decision, page 199 of the bundles, the core bundle. The evidence we have of a positive decision not to accept lifetime benefits last being made by Mrs. Staveley was in June 2006. And then later on in the paragraph, there is no evidence she thought about it again. Likewise, paragraph 124, referring to that October letter from Hawes, the first-tier tribunal, so there's no suggestion in that letter that the transfer to the PPP would lead to a reappraisal of the decision not to access the lifetime benefits of her current pension policy. There is no suggestion that her view ever changed. And of course, the June date when the FTT, so it was the last evidence of her making the decision, was 4 months before the intellectual acceptance that her prognosis was fatal. Question simply here for the court is not what would your lordships have found were your lordship, my lady, have found were you sitting as first instance judges. Was the first-tier tribunal entitled to find that there was no common intention between the transfer and the omission? And my answer to that is simply yes. These were two commercial pension funds, each with the possibility of death benefits, which by definition were always going to be payable to someone other than Mrs. Staveley. She moved from one commercial product to another. Why did she move? FTT found because she understood that there was a possibility of a risk that under the first scheme, her former husband might somehow get something. The position was analysed by the upper tribunal at paragraphs 35 to 37 of their decision. I would commend that analysis to your lordships. It's at page 162 of the bundle, and concluded at the bottom of paragraph 137 that the finding that the transfer, that the sole motive was the exclusion of her husband, can also be understood as a finding that but for that risk, Mrs. Staveley wouldn't have made the transfer, but would have allowed the status quo to endure and for her sons to benefit as she planned under her will. That was the sole reason, and in my submission, the FTT were entitled to reach that conclusion. The only other point perhaps I should just make in relation to the Edwards and Bairstow issue is there was another case I refer to in my written case, Procter & Gamble and IRC. I refer to it simply because it identifies the importance on an appeal of deference to findings of fact by a specialist tribunal. And of course, that's what we have here.
You just give us the reference to that, please.
Procter and Gamble is at tab 16, page 492 of the authorities bundle, and the particular passage that I'm referring to is in the judgment of Lord Justice Jacob at paragraph 11, which is page 496 of the internal numbering. It's also important to bear in mind that this case is concerned with an appeal from a specialist tribunal. Particular deference is to be given to such tribunals, for Parliament has entrusted them with all their specialist experience to be the primary decision maker.
Yes, he's referring to Lady Hale's judgment in A.H. Sudan, which is well known, yeah.
Unless I can assist further on the transfer issue, looking at the time, I was going to move on now to my argument in relation to the omission.
Yes.
This is the second issue in the case, and whether the omission by Mrs. Staveley to take lifetime benefits is to be treated as a disposition for the purposes of Section 3.3 of the Inheritance Tax Act. The relevant provision is at page 291 of the authorities bundle, and provides that where the value of a person's estate is diminished and the value of another person's estate is increased by the first person's omission to exercise a right, he shall be treated as having made a disposition at the time or the latest time when he could have exercised the right, unless it was shown that the omission was not deliberate. I've omitted there, in reading that out, subsection B, which is the reference to settled property, which is not relevant on the facts of this particular case. So breaking that down, there are three events that must happen for an omission to be treated as a disposition. Firstly, there must be a deliberate omission by a person, the transferor, to exercise a right. Secondly, the transferor's estate must have been diminished by the omission. And thirdly, the value of another identified person's estate, that's my submission, that it must be an identified person's estate, must have been increased by the omission. So the omission must cause two things: a diminution in one person's estate and the increase in the value of another person's estate. Now, Section 3.3 is a matter of much wider relevance than simply pension schemes. And indeed, so far as pension schemes are concerned, it's primarily now only of historical interest. The Revenue's historic practice was not to apply Section 3.3 in what they termed cases of genuine pension arrangements, but their guidance, and this was simply informal guidance, but it's in the bundle at page 565, is that we would consider raising a claim in such cases as remain only where there was a prima facie evidence that the policyholder's intention in failing to take up retirement benefits was to increase the estate of someone else rather than benefit himself or herself.
May I ask, where is that taken from?
That's from a letter that the Capital Taxes Office published to the Association of British Insurers.
Do we have that in our bundle?
It is. It's page 565 in your
Tab
Lordship's
22.
bundle.
Thank you.
In April 2006, the position changed, and there was a complex series of amendments to Section 12 of the Inheritance Tax Act. And those were the issues that were looked at by the first-tier tribunal relating to Section 12, 2A, 2B, and 2C. I don't need to take Lords my Lady through those in any detail because they're no longer of particular relevance on the facts of this case. But suffice to say that there was a parliamentary scheme whereby certain omissions to exercise pension benefits would be ignored. That was replaced in turn in April 2011 by a new provision. This is what is now Section 12 2ZA of the Inheritance Tax Act. This doesn't apply in Mrs. Staveley's case, but now represents the law since 2011. That is in the authorities bundle at page 359, and that essentially excludes an omission to exercise pension rights under a registered pension scheme in the scope of section 3.3. So far as pension schemes are concerned, this is now, as I say, only of historic interest. Now, our case, my lords, my lady, is that the upper tribunal were correct in their conclusion at paragraph 82, their decision, which is at page 172, which is that the word by in section 3.3 requires that an omission is the proximate cause of the increase in another person's estate. And as the upper tribunal held there, where such an immediate and proximate cause exists, a more remote reason why an estate is greater than it otherwise would have been is unlikely to satisfy the statute. An effective intervening event without which the person's estate would not be increased will in most cases be sufficient to break the necessary causative link with the original omission. The points that we make in relation to the construction of section 3.3 are set out at paragraphs 95 and following of our written case. Firstly, we would make the submission that the use of the word by, preposition by, in section 3.3 is being used in the sense of means or cause or reason, and that the natural and ordinary wording of use of the word in this context connotes a close causal connection. That's not to say it's simply a cause of the state of affairs, but it must be the cause of the state of affairs. And contrary to what Lord Justice Newey said in the Court of Appeal, we would submit that but for causation isn't satisfied. We would also contrast the fact that Parliament uses in section 3.3 the word by as the relevant word in relation to the increase in value, increased by the omission, whereas in 3.1 Parliament, referring to transfers of value, referred to as a result of which the value of the estate immediately after the disposition is less than it would be. So there's a distinction used there by Parliament between the words by in 3.3 and as a result of in 3.1. And we would suggest that in 3.1 the use of the indefinite article perhaps suggests a less immediate degree of proximity than that's required by section 3.3. The formulation increased by also appears elsewhere in the statute. For example, section 199, and your lordship, my lady, finds that in the authorities bundle at page 345. This looks at who is liable for inheritance tax as a result of a chargeable transfer. And the persons liable are A, the transferor, B, any person the value of whose estate is increased by the transfer, and C, so far as tax is attributable to the value of any property, any person in whom the property is vested. And again, we would submit that in that context, where Parliament is using it to define liability to a tax, increased by, again, would suggest the immediate proximate cause and not simply but for causation. My fourth construction point is one I have made in various forms with greater or lesser enthusiasm in terms it's been received by the other levels of judiciary who've considered this, but I do say that there is, in the use of the present tense, is diminished and is increased, a connection that the diminution and the increase should be caused by the same event. I would say at or pretty much at the same time. But they do need to be caused by the same event, not one being caused by the omission and the other being caused by the omission and something else. So here the diminution is caused by Mrs. Staveley's omission to exercise her right, but we would say that on any footing the increase in the son's estates is caused by the omission and by the subsequent exercise by the scheme administrators of their discretion. Also make the point, which is the one at paragraph 100 of our written case, that the FTT recognised that given a literal construction, section 3.3 might never apply at all, because it's not just the omission, but it's the omission of Mrs. Staveley's death that gave rise to the diminution in her estate. And therefore the FTT recognised that they were giving a purposive construction to the section, to say that diminution and increase should be caused by the omission to exercise the right at the latest time which it could have been exercised. Having adopted what the FTT essentially recognised was a purposive construction, in my submission there's no need to go further and say, and one can also ignore, for the purposes of causation, subsequent and independent events. And I do make the point, and again this is paragraph 102 of my written case, that where one adopts but for causation, where does one draw the line? Because one can have a long chain of events. Here, the son's estates were increased by Mrs. Staveley's contribution to the Morayford pension scheme in the first place, by the transfer out of the Morayford scheme into the Section 32 contract, by the transfer from the Section 32 contract to the PPP, by the omission, by the death, by the exercise of discretion. In my submission, each of those may have played a part in the son's estates ultimately being increased. But what were they increased by? They were increased by the exercise of the scheme administrator's discretion. I mentioned my argument that one needs an identified person. This was a point that was picked up by the upper tribunal at paragraph 85 of their decision. That's page 172. And what the upper tribunal said there is, nor in our judgment does section 3.3 apply where the increase in question is not of an estate of an identifiable person. Miss Wilson argued it was immaterial how the scheme administrator exercised its discretion. However, the discretion was exercised, there would be an increase in the value of some person's estate. We do not consider that to be a tenable argument having regard to the terms of section 3.3a itself. What is required is that there be an increase in another person's estate. It must accordingly be possible to identify, by reference to the required causal link, a particular estate or estates that has or have been increased by the omission. Were that not to be the case, it would be possible for section 3.3a to apply to a class of discretionary beneficiaries under a trust. Just to interpose there, my lords, my lady, of course, under a trust, the rule against perpetuities means that somebody will get something out of the trust at the end of the day, possibly in 125 years' time, but they will. That such an outcome was considered not to be possible is evidence from the inclusion in 3.3b of a special provision for an increase in the value of settled property itself. Absent such special provision for a class of discretionary beneficiaries outside of settled property, it's not possible to construe section 3.3a to the same effect. I also make the point in our written case at paragraph 104 that the revenues interpretation gives rise to timing and practical difficulties. Disposition under section 3.3 the disposition can't be made until the son's estate is increased because the conditions haven't been fulfilled. One needs the omission, the diminution in value, and the increase. But once it has happened, in this case 6 months after death, but it could have been 2 years after death, that disposition is deemed to have occurred immediately before Mrs. Staveley's death, because that's the consequences of the wording of section 3.3. And this means that persons who may be under a statutory liability to deliver an account within 12 months of death, or 12 months of the date of a transfer, will find themselves already out of time, because by the time we know that the disposition has even occurred, it'll be more than 12 months afterwards. How in those circumstances, just in practical terms, can such a person fulfil their obligations to report the transfer to the revenue? My learned friend makes a point in her written case that my construction would lead to contracts and trusts being treated differently, and my learned friend says this can't be Parliament's intention. But the whole nature of the way the Inheritance Tax Act is drafted is that trusts and non-trust property are treated differently. Your lordships will see that section 3.3 doesn't apply to omissions by trustees. Where one has an omission by a trustee, that is dealt with separately. The provision, it's not, I'm afraid, in your lordship's bundle, but it's section 65 of the Inheritance Tax Act. And section 65, subsection 9 of the Act provides that an omission by trustees, unless it's not deliberate, will be treated as a disposition. There's no equivalent to the need to establish a diminution in value and an increase in value there. So there are different provisions relating to trusts and contracts in the Act, and in my submission it's not remotely surprising that there may be different consequences on the facts of this particular case if they've been applied to a trust rather than a contract. So in my submission, the definition of section 3.3 is that it must be the proximate cause and not but for causation.
Can I just go back to the wording of the section itself?
Yes.
Look to see that what you're looking for is ultimately going to be a disposition deemed, but disposition at the time when he could have exercised the right. And the conditions for that, as you've gone through, are the specific person's estate on your submission is increased and the transferor's is decreased.
Yes.
And I'm just being very simplistic about this. That has not happened at the time when the disposition is taken to have happened.
The disposition is deemed to have taken place immediately before death.
Yes, and
Yes.
that has not happened at that point
No.
because it awaits the discretionary exercise.
But nonetheless, I would say that the use of the word by is looking at the reasons why the increase has happened and why the diminution has happened. And on the facts of this particular case, the reason is not just the omission, but it's a subsequent intervening event as well. Now, the Court of Appeal were all three members of the Court of Appeal were entirely against me on that point. But Lady Arden then made further comments at paragraph 68 of her judgment. I will take your lordships to those. That's at page 137 of your lordship's bundle. Having agreed with Justice Newey that but for causation is sufficient, Lady Arden continued, as I see it, HMRC seek to establish a rule that the administrator's discretion will always be left out of account. In agreement with the FTT, I consider that determination of whether there was an increase in the beneficiary's estate as a result of an omission must depend on an assessment of the relevant facts. Here, the decision for the administrator was relatively straightforward. The nomination had been recently made and were consistent with the demonstrated intention of Mrs. Staveley as expressed in her will. But it is possible to envisage cases where the nomination was made a long time before death, or events have occurred which would lead the administrator to consider that the wishes of the deceased should not be followed. In those situations, the court may consider that more weight has to be given to the discretion of the administrator in deciding whether Section 3.3 is fulfilled. I need not express a final view on that point, but I would wish to leave that question open. Mr. Justice Burse, at paragraph 116, expressly agreed with Lady Arden's further observations of paragraph 68. In my submission, though, what Lady Arden is saying here at paragraph 68 is inconsistent with Lord Justice Newey's view that but-for causation is sufficient. Because what Lady Arden is, in my submission, saying here is that she is rejecting HMRC's contention that discretion must always be left out of account. And she says, well, it depends on the facts of the individual discretion. It depends, for example, how long before the nomination was made, or whether there has been a change in circumstances. And in my submission, that's a lot closer to what the first-tier tribunal decided on this point. Their decision is at 113, paragraph 113 and 114, at page 194. And the first-tier tribunal said, ordinarily, we would regard the voluntary exercise of discretion as a break in a chain of causation from the omission to exercise a right before death to the receipt. But is it right to do so where it's common knowledge the pensions administrator will normally and perhaps invariably exercise its discretion in accordance with the deceased statement of wishes? And they continued after referring to the case of Drummond that my own friend had cited. We are entitled to take into account the owner of the pension policy has every reason to expect their statement of wishes to be respected. It would be wrong to regard the pension administrator's legal discretion as a break in the chain of causation. And it's virtually inevitable he would honour the deceased's wishes and pay the money directly to the sons. Now, that conclusion of virtual inevitability was quashed by the upper tribunal, because there was no evidence here that there was a sham. There was no evidence as to how pension administrators go about exercising their discretions. And the upper tribunal concluded at paragraph 74 of their decision, which is at page 170, that it was open to the first-tier tribunal to find only that there was a genuine exercise of discretion by the scheme administrator, and that the most Mrs. Staveley could have expected from her completion of the expression of wishes was that a diligent administrator would take those wishes into account as a relevant factor in the exercise of its discretion. In my submission, Lady Arden at paragraph 68 in the Court of Appeal is falling into the same trap that the first-tier tribunal fell into, which is to start looking about how the discretion was exercised. If Lady Arden suggests that if the nomination had been given longer before Mrs. Staveley's death, or there had been a change in circumstance, that might be relevant and break the chain of causation. Well, what would have happened if one of Mrs. Staveley's sons had died after Mrs. Staveley's death, leaving issue, and the pension fund administrator had appointed money to them? Would that have broken the chain of causation? It was rather, Lady Arden's judgment rather suggests that it would have done. But why is an exercise of a discretion in those circumstances any different to an exercise of a discretion when both the sons are living? Once it's been accepted that the exercise of a discretion is capable of breaking the chain of causation, the question of how that discretion is exercised factually is irrelevant unless it's a sham. If it's a genuine and independent discretion, and there was no evidence before the FTT on which it could have reached any other conclusion, in my submission, the chain must have been broken. only appropriate conclusion that the FTT could have come to was that which the upper tribunal identified at paragraph 74. Those are my submissions on the omission element. Is there anything further I can assist with?
Not at this stage, I think. There may be more questions once we've heard Ms. Wilson. Mr. Cumber, do you follow? Ms. Wilson.
What I'd like to do is go through in the same order. So section 10, 1, 268, then 3, little 3. But before I start with section 10, I'd just like to remind the court of an important feature of this case. And that's that on the 9th of November 2006, when Mrs. Staveley procured, by exercising rights under the Section 32 policy, that a payment be made of the policy monies from Sun Life to AXA. And note, that's the disposition, and that's the transfer in that is referred to in the notice of determination. So that's the disposition. She had as good as made her gift of the death benefits to her sons, in the sense that she'd done everything she could to secure that that would be the result on her death. And there is a finding of fact at paragraph 61 of the first tier's judgment that she made the decision not to take lifetime benefits. And I will come back to this in more detail, but it's important to get back to actually what happened in this case. She made the decision not to take lifetime benefits, again in respect of the personal pension. So she had a decision which was operative in respect of the payment into the PPP, not to take lifetime benefits so that the death benefits would be paid. And she completed, on advice, the statement of wishes that the sons be the preferred beneficiaries of those death benefits. And so it's in that context that, where we've evidence of an intention to confer a benefit in respect of the policy monies, which are being the subject of the disposition, that's the context of this scheme, and in a sense why we're here. And it's why the revenues say, well, how can Section 10 apply in those circumstances? And we say, well, the only argument should be which route do you take to find that Section 10 doesn't apply. But in our submission, it should be clear that exemption for wholly commercial transactions isn't available here. And then secondly, it feeds into the omission to exercise a right, which I'll go into later. But as I say, it's just to get our feet back on the ground, as it were, as to relation to that's what happened on the 9th November.
Yes, but the revenue's position is the disposition. There is a disposition because of a reduction in the value of Mrs. Staveley's estate by reason of her surrendering her rights under the Sun Life policy and her reinvestment in a new pension scheme under which she had different rights to dispose of the fund.
That's my first substantive point on Section 10.1, which is it's very important in this case to distinguish between the disposition and the transfer of value. They're two different concepts in the Inheritance Act, and Section 10 itself shows us that not every disposition will end up being a transfer of value. So the disposition is that payment of monies on the surrender of rights under one scheme, and then the contribution, the payment into the PPP. The payment of money is the disposition. The next question is, well, did that give rise to a transfer of value? And Section 3 tells us a transfer of value is a loss in the value of the estate of the person making the disposition. And that's when you then look at the rights. You look at what rights did she have in her estate before and after the disposition? And was that loss in value caused by the disposition? And it's that they shouldn't be elided simply because they are different legal concepts in the Act. Thank you. So, and the second point on Section 10 that I want to make is, you'll see what I'm going to do is just go through and make a few preliminary points about Section 10 itself in the context of this scheme, and then I'll go on and make submissions about how it applies on the facts of our case. So first point, you must distinguish a disposition from a transfer of value. Second point is Section 10 can only apply if there's a disposition which is a transfer of value, because its job, what it does, is to say, although it would be a transfer of value, but for this satisfying the conditions of Section 10, it's not. So if you have a case where there's a mere reduction in rights, you've made a gift into settlement, and you reduce that by taking back something, whether or not that's a disposition, and it may well not be, there would be no transfer of value. So you would never ask a question about Section 10. And I make that point because in the judgment of the Court of Appeal at paragraph 85, Lord Justice New is concerned that when we analyse Section 10, we ought to come up with some kind of analysis which works equally or in the same way for reductions in rights as to substituting rights. And I say that's going wrong, because if you merely reduce a gift that you've made and take something back, there won't be a transfer of value. So Section 10 is not interested. So again, it's just sort of clarifying the basic building blocks of Section 10. The other reason, perhaps more profoundly, why it's important to analyse what is happening in the disposition in terms of, is it a reduction in rights or is it a substitution, is that if you substitute rights, which is really our case, if you change how a gift is made, first of all, you've got the possibility that there's a disposition which is a transfer of value. But secondly, the implication is that other rights have been extinguished or lost, or promised benefits have been taken away. And that's very important in a case like this, because it's part of understanding what has actually happened as a matter of law, fact, and reality. And until you work that out, you shouldn't begin applying Section 10. And the particular questions that analysis raises, when rights are substituted, so some rights have been extinguished or changed, which is, well, how did that come about? Is this a case where the sons had actually acquired a vested right to a benefit which couldn't be taken away from them, and they bartered with Mrs. Staveley? They said, you're not going to make that disposition unless you give us, because we've got a right to compel you, an equivalent right. So that would be a different kind of transaction altogether. Or is it a case where the sons had no right at all, and that's our case, to anything? They had a hope of benefiting. And their hopes even are extinguished by the disposition that's being planned. And the question then that is entirely different. You can see then that, and this is our case, and in my submission it's what Lady Arden was getting at, that was her insight, is that in that case substituting the benefit, even if it's incredibly similar, is I would say on analysis a benefit, because the comparison on analysis is that the sons have nothing. They haven't bartered for this new substituted gift. They've been given it. It's been conferred on them. And that's why I say Lady Arden was right, because to break down the analysis into, in this case of substituted rights, what rights, if any, were created and extinguished? Was there a novation? What happened? Secondly, on a detailed legal analysis, did the creation of the new rights confer a benefit within the statutory words? And then thirdly, on the facts found, was that situation something she intended? That only that final question is a matter of asking what was in Mrs. Staveley's sort of subjective mind. Now, we do have the case Vodafone in the bundle, which has the sort of classic exposition of subjective purposes, and I can give you the reference to that. It's at page 559 to 560 of the bundle. And the Court of Appeal make the point there, when you judge subjective purposes, it's a question of fact, but always with a dash of common sense. There'll be cases, and it's not limited to conscious motives, and it's certainly not a question of just asking the person what they think, because that tends to muddle the law and the fact. It's an analysis of what they intended. It can be quite simple to apply when a simple gift is made, but once you have financial products being purchased which involve within them the possibility of making gifts, it obviously becomes more complicated. The other point that's made by Vodafone, or is clear from it, is that the court often has to do quite a lot of work to determine what the subjective intentions of an individual is in entering into a transaction. And this is an error that the first tier made. You don't just ask, if you're changing financial products, you don't just ask, why did you want to leave that product? You also have to ask, because there could be a very interesting answer, what is it that the new product importantly has to do for you in order for you actually to go ahead and make that change? And I'll come to this when I look at the facts, but what the error of law that the first tier made was to stop at the first question. And that's why they got to the finding of a sole motive. That's paragraph 48 of their decision. They said that her sole motive in making the transfer was to break the connection with the ex-husband. But they'd only asked that first question because when we look at all the other facts found by the first tier on the face of their decision, it was absolutely important to her that the sons got the policy monies as death benefits on her death. And there's no finding that she would have made that change or that transfer had it risked the son's inheritance. It's a further point about Section 10 is it is a relatively narrow provision. The basic charge to inheritance tax is on transfers of value, and we've got one here. It's not a matter of construing it narrowly. That's how Lord Justice Newey put it. He said, I don't think it's right that we should construe it narrowly. It's actually how it operates. It is constructed so that it is a narrow provision. It's very, very easy to trip one of the conditions that means you fail Section 10. You can have 10 hugely commercial purposes, but 1/11th intention to confer a benefit on any person means that you don't get the exemption. And of course it's extended by the series of transactions and associated operations. And it has further tests about arm's length. So it simply is quite a narrow provision. I mean, and plus, as Lady Arden pointed out, the burden of proof is on the taxpayer. that's all consistent with the fact that if you've got a transfer of value, you expect to charge inheritance tax. You need to justify why you're not paying inheritance tax when there's a transfer of value. A further point, and I've just got two more introductory points on section 10, is, and perhaps I've said this already, but identifying the subjective intention of the transferor is a question of fact. But how you characterise that intention as an intention inside or outside section 10 is a question of law. And I make that point because in my submission, much of the analysis of the courts below have confused questions of fact and law. And it may have come from the focus on section 10 using ordinary English words. And the temptation has almost been to ask, well, would Mrs. Staveley have described herself as conferring a benefit on her, as intending to confer a benefit by the transfer? But that's in my submission to confuse facts and law, because you haven't adequately particularised the question you're asking. And that question is the question of law, which is, what do you mean by benefit? What do you mean by improvement? Improvement by reference to what? And until you tell Mrs. Staveley what that test is, her answer isn't going to give you the answer for this case. You see that sort of slipping into the analysis, I would say, in any judge that's held against the revenue, but that there is sometimes this just slipping into, especially with the reference to, the sort of use of ordinary language. The analysis often slips into confusing questions of fact and law, and that's something that shouldn't be done. So here, the particular question is, what do the words intention to confer a benefit mean in this case where a substitute benefit is conferred? And is that in or out of section 10? Now, I say that, without committing myself too heavily, I accept that ordinarily an intention to confer a benefit involves some element of intending to improve a person's position. But I obviously don't intend to concede my case by saying that. That's just a general sense of what we mean by confer a benefit. What the difficult question in the case of substituted rights is, improve the recipient's position in comparison to what? That's the question. And it's a question of law, I say, following Lady Arden, to be determined by a detailed legal analysis of the facts of the disposition. And my case is that on that detailed legal analysis, the son's position, the recipient, the son's position is as follows. They have no entitlement at all, no rights under the Section 32 policy. And it's worse than that to break the link with the ex-husband, all of their even hopes of benefit are extinguished. Because to break the link with Moriford, she surrenders, extinguishes all the rights under the Section 32 policy, apart from the one which can require her to make Sun Life pay the money over to AXA. And so that's when you're asking, was their intention to improve the son's position or confer a benefit on the sons by making the substituted gift or providing for the substituted gift under the PPP? I say the answer is yes, because the sons were just mere hopeful donees under the Section 32 policy. They couldn't force her to make her a replacement gift under the PPP. They had no rights that they could exercise or enforce. They were reliant on her remaking a new gift in their favour so that they wouldn't be worse off. And in my submission, that, as a matter of law or characterisation, is an intention to, when Mrs. Staveley did that, intending to do that, she intended to confer a benefit as a matter of law under Section 10. Lady Arden, in her judgment, talks quite a bit about the fact that it may well be that the rights under the PPP were in fact rather better, arguably, than the rights that they might have had if you combine the Section 32 policy and the will, because you take under a will after testamentary expenses and anything could happen, whereas they were actually named and they were a class in the rules of the PPP. As I see it, the substance of what Lady Arden was saying there was, well, you still have to ask whether what the sons got was a benefit. And in this case, it's a sort of strong case that what they got was a benefit, because not only was it a right, the rights in respect of £715,000, and the opportunity to obtain that money is clearly a benefit, sort of self-evident. But in fact, this is quite a strong case, because you might say that the rights that they had in respect of that gift were better under the new than the old. But I don't necessarily, I'm not interested in sort of founding my case on that. I just see that that's evidence that, of what is self-evident in any event, that what's conferred as a benefit. So then I say, well, that's how you should approach Section 10. You start with a detailed legal analysis of what has actually happened in order to determine the comparison that you're making, in order to determine whether there's been an intention to improve. But the final question always is, well, what's actually happened in this case in terms of her subjective intentions? What did she intend? Did she confer this benefit by mistake, or was it one of her intentions? And I say, obviously, not. This wasn't a case where she didn't realise she was leaving the Section 32 policy. One of those cases where you intend a variation of contract by just omitting one term, but you don't realise that you've made a disposal or something along those lines, or that she was so ignorant of what was going on, she didn't even know she'd done anything at all. That's not this case. This case, Mrs. Staveley was very well appraised of what was going on. Yes, of course, and it's common ground, one of her objects in making the payment, the disposition, was to extinguish all connection with her ex-husband. And she achieved that object by extinguishing all her rights under the Sun Life policy and procuring the payment into the PPP, the personal pension. But another important object of the payment, on the face of the First-Tier Tribunal's decision, was to purchase rights to confer the death benefits on her sons. Because remember, she was dying. She certainly was understood that by 31st of October when she was filling in the application forms, and on 9th November when the money was paid. And in fact, we know she died 6 weeks later. So where this £750,000 was going to go was obviously important. And I'm not just saying I wish that had been found as a fact. It is there on the face of the decision, and I'll show you. So you might say, well, what was her motivation for leaving the Section 32 policy? To break the connection with Morrowford, her ex-husband. But what had to also be affected by the payment if she was actually going to go ahead and make it? And I say it had to make that gift of the death benefits to the sons. And then I'll show you, but perhaps I should do that after sort of don't. But I'll show you that that's what the tribunal found. And where I part company with the tribunal is the inferences they made from their primary findings of fact about what happened and what her intentions were. For example, sole motive, whatever. Well, no, actually, I've got 5 minutes, so I can make a good start on the facts. So the first tier's decision is at
We
It
have it at
starts-
174 of the bundle.
starts at page 174. If I could start at paragraph 16 of the decision. And this was a finding in relation to one of the younger son's evidence. So he expressed the view that while she wished her sons to benefit from her pension fund, she would rather they got nothing than her ex-husband benefit from it in any way. We reject this, as we find there was nothing more than his opinion and not factual evidence, as it was not a choice that had arisen in her life, and she'd never been asked to express a view on it. We do, however, accept the overall tenor of the evidence, that preventing Morrowford receiving a benefit from her pension fund is very important. But we also accept Mr. Pinney's view that it was also very important to her that her sons did benefit from her estate. And then there was no finding about IHT. So there was a rejection of a proposition from one of the sons that she so hated her husband that she would risk her son's inheritance just to get away, break that link. That was rejected as a proposition. And what the tribunal is really saying there is that, what they say is receiving the sons were very important to her, and it was very important to her that the sons benefit from her estate, which at that time would have been the taking the death benefits through the will.
Can I just ask, as a matter of theory, would Ms. Staveley have been able to simply waive any rights that she had under the Section 32 policy? Just say, I just don't want them, and thereby cancel them out? The husband would get nothing that way.
Well, I suppose she could have said to Sun Life, you can have all my fund. I don't understand it was ever put to her.
Yes. Her husband's getting
Yes.
money if she...
Yes. Or she could,
If she had that power, but
she
that's
could have
not-
assigned possibly all the rights under the pension to a charity or something, I suppose. It wasn't explored in evidence, but...
Yes, thank you.
No. Yes, she could have given the entire fund away to somebody else. And then at paragraph 61, which we saw earlier this morning, and this was a finding in relation to associated operations, but all of the findings, including, and I'll come on to them, the findings which arose out of the Section 12.2a, another legal point, they are all findings of fact by the tribunal. They were all views taken by the tribunal on what had happened. We can't ignore some facts just because they arose out of an argument no longer pursued by the appellant here. But paragraph 61 here, so it begins talking about associated operations. The use of the word associated presupposes there's some connection between operations for them to be associated. 268 should be read as requiring. We find as a fact they were not. And then what they find is this. Mrs. Staveley's decision not to exercise her pension benefit was a continuing decision. That's a finding of fact, which she made in respect of both the Section 32 policy and the PPP. Now, for that to be right, and it obviously is the case because it makes total sense, when she paid the money into the PPP, she operatively and realistically had the decision, she was applying that decision not to take lifetime benefits under the PPP, just as she'd been applying it under the Section 32 policy.
Well, in what sense was she applying it? I mean,
Well-
let's assume she had still had it in mind that she wouldn't take
Well,
benefits.
what she would have had in mind is that because she filled in the statement of wishes and her advisor told her that was imperative, she had in mind the positive spin on the omission, which was she wanted to give the policy monies to her sons as death benefits. But that is a decision not to take lifetime benefits. It's one and the same. So you can call the omission. It's difficult to think about an omission because it's always a not doing. But this was and it was found as a fact, a deliberate omission. She did make it in June, but it remained the basis upon which she managed and made decisions about what to do with both the Section 32 policy and the PPP. And they go on to say, the tribunal, nothing changed in this respect when the transfer from the Section 32 to the PPP took place. Now, they go on and say they were entirely independent, and I will say when we come to the associated operations point that is a total contradiction of what they've just found as a fact above. But just at this stage, I just draw your attention to that finding, that there was a continuing decision made in respect of both policies.
Now, I wonder if we might perhaps be at a convenient point to adjourn.
Thank you.
Very well. 2 o'clock.